Good afternoon, everyone. This is Jim Peterson. My partner Neil Marchand and I pre-recorded this session of Lessons from Litigators because Neil had a conflict that came up at the last minute for today. So we will play that recording, and then I'm here live and I'll be able to take questions. So I hope you benefit from today's presentation, and I look forward to speaking with you later. Thank you.
Good afternoon and welcome to our next edition of Lessons from Litigators. I'm sorry I'm not able to make it today, but we're pre-recording this, and Jim will be around afterwards to answer questions live. We are going to be talking about protecting your legitimate competitive business interests. And this really has to deal a lot with employees and business information, right, Jim?
Yes, correct. And that's really what courts look at, right? Whenever you're trying to protect either your information or your relationships, courts determine those to be legitimate competitive business interests, which are required in order for courts to enforce agreements.
Right. And so we're going to talk about what information can be protected and then share some tips that we have for protecting your legitimate competitive business interests. What information can be protected?
Well, first of all, confidential information, and it really is the company that determines what is confidential, right? You can define what is confidential in your agreements. It helps to be both broad, inclusive, and also specific in that, and identify different categories of your information that you consider to be confidential and that you get your employees to agree to treat as confidential, and get them to commit that during the course of their employment and even after they leave, they will preserve the confidentiality of that information.
But what about information that's already out in the public or on the web that we can just Google? Is that really going to be confidential information?
Well, that's a gray area, right? And we always tell clients that the primary benefit of any kind of agreement is voluntary compliance. And so if in your agreement with your employees, you categorize and define things as confidential, they are more likely to treat them as confidential, even if they might have an argument in front of a judge at a later time that it really is in the public domain. But it really is that primary benefit of the agreement, and you get kind of your employees to buy in to protect confidentiality as part of that.
And do you limit your the definition of confidential information in your agreements? Do you limit that to strictly the employer's information, or is it broader to include information about their customers or?
Oh, sure. Yeah, I think it's a good idea to be broader, to include not only the employer's information, but also information that their customers expect them to treat as confidential, or that their vendors expect them to treat as confidential. So often the agreement is drafted in such a way to specifically provide that it's also customer information and vendor information that they have to treat as confidential.
And the other type of information is trade secrets, right?
Yes. Yeah. Trade secret is defined as information that derives independent economic value to the employer by the fact that it is secret, not known by others, and is the subject of reasonable efforts to maintain its confidentiality or its secrecy. So I was going to ask you, Neil, between those two designations of confidential information and trade secrets, which are easier to protect by way of judicial enforcement?
Confidential information is by far easier to protect by way of judicial enforcement.
And why do you say that?
Because the hurdle and the standard for proving a trade secret is so high. In 13 years, I can only think of one case that we've had where a court has found a trade secret. But confidential information, by virtue of the parties agreeing that this information is not out in the public, that that the employer derives a benefit from it, courts are much more likely to enforce that and say to the employee or former employee that this information really does benefit the company and there's some proprietary value to the company by keeping it confidential and not in the public domain.
And is that why employers shouldn't just rest on their legal rights under, for example, the Uniform Trade Secrets Act or the Federal Defend Trade Secrets Act, and actually proactively require their employees to sign agreements?
Absolutely. And I get this question a lot of, if I can't prove a trade secret, why should I have this agreement? Why should I have a non-competition agreement? And it's really broader than just direct competition with the former employer and a new employer. It goes to things such as protecting the confidential information of the former employer, and it gives the entity that has the information much more leverage in protecting its information in the event a dispute arose.
Great. Yeah, I tend to agree with that. And that's why anyone who has access to confidential information should be required to sign a confidentiality agreement. You know, there ought to be provisions in an employee handbook, right? But that's not necessarily enough, because often companies have provisions in their handbooks that purport to protect confidentiality, but they're not contractual in nature. And so the handbook often has a disclaimer, in fact, that says this is not a contract. And so it's much better to have, if you're going to have a handbook, to have certain provisions that are contractual, or to have standalone agreements.
Yeah, my preference is a standalone agreement. The initial offer letter containing the restriction on confidential information and different competitive activities, as well as a separate employment agreement.
Yeah, exactly.
So let's share some tips from our experience about protecting legitimate competitive business interests. The first one goes back to the voluntary compliance with contracts. Having a confidentiality agreement with the employee that specifies what the employee is going to keep confidential.
Right. And I think it's important, as I said before, to be broad in that, in how you define confidential information. Also to have a requirement that upon termination of employment, the employee is obligated to return any confidential information in his or her possession, and really any company information in his or her possession.
And do you include anything else in the return provision, like company property, laptops, anything of that nature?
Yeah, anything that belongs to the company, there should be a separate contractual obligation for the employee to return.
What about a non-solicitation agreement with employees? I find that this is a more enforceable. Courts are more readily to enforce an agreement with an employee that says the employee will not solicit the employer's customers or the employer's other employees for employment than a broader non-compete and that restricts them from doing the same job in the same industry.
Yes, I think that's right. And a lot of courts are reluctant to put someone out of a job. That's particularly true in times where it's the unemployment rate is higher. It's a little less true now, at least as a rationale for refusing to enforce an agreement. But not only are courts more likely to enforce it, but I think employees are more willing to sign non-solicitation agreements too, that don't prohibit them from working in the industry.
And then we were talking about the non-competition agreements. Have you seen cases where courts have actually restricted an employee from performing the same job for a direct competitor in the same industry?
Yes, I have. Some judges do it quite willingly, and some are more reluctant to do it and will require some indicia that the employee can't be trusted to simply have obligations imposed by court order not to use or disclose company information and not to solicit certain customers. So it varies depending on the court and depending on the judge and also the circumstances. But I think it's a good idea to have a non-competition agreement in place with employees because, again, we get back to voluntary compliance. And then we also get back to just protecting the company's negotiating position. In essence, if someone leaves, right? I mean, you want to make it less likely they'll go to a competitor. You want to make it less likely a competitor will hire that person. And then if they go, you want to have the maximum amount of leverage to negotiate restrictions that you can live with.
And so how do you respond to the client who says, if everything is judge specific, should I have a broader scope on these restrictive covenants, the non-solicitation agreements, the non-competition agreements, or should I go more narrow because it's more likely to be enforced?
So what I usually advise clients in Michigan that they're better off with a broad agreement, because Michigan is a blue pencil state, what's called a blue pencil state. And what that means is courts in Michigan, if they find that an agreement is somewhat overly broad, either with respect to geographic scope or with respect to duration, they will modify the agreement to either narrow the geographic scope or shorten the duration to make it reasonable. But just having an agreement that is slightly too broad is not a problem in Michigan, at least. Some states, on the other hand, if an agreement is too broad, they will simply strike it down and they won't modify it. And for clients in those locations or seeking to enforce an agreement in those locations, we have to be much more narrowly tailored.
So we have to look at the jurisdiction where the employee is going to be employed to see how broad to draft that agreement.
Yeah, exactly. But as you know, right, you can also have choice of law and forum selection provisions that will assist you in a more employer-friendly location if you do end up having to litigate this.
And hopefully that's not California.
Exactly. Neil, when we were preparing this slide, you mentioned controlling information and to whom it is sent. What do you mean by that?
What I meant by that is when a company has proprietary information or maybe a confidential drawing, knowing to whom it is sent, having the agreements in place, maybe with their customers or their vendors, that protects the confidentiality of that agreement, where the customer or the vendor says, I'm not going to redisclose this or share this with someone else. And keeping track of that information and having the processes in place at the employer's headquarters to keep the information confidential, and so that employees who should not have access to that information do not, in fact, have access to it.
Have you run into cases where that's been an issue, where broad dissemination of information that the company would like to protect creates problems with enforceability?
Yes, I had a case where we were representing the employees against the former employer, and the former employer widely disseminated a lot of their internal information that they were now claiming was confidential. And that posed a problem. There were courts that held that even with this confidential stamp on the drawing, the former employer waived the confidentiality of the information by having it widely disseminated in the industry, by not restricting its customers' use of that information, and by not restricting its vendors' use of the information.
Is that why sometimes you recommend to companies that they have their customers enter into confidentiality agreements regarding particularly sensitive information?
Yes, both their customers and their vendors, so that the customer understands that it's under that obligation to protect the information. And it helps as well when the customer receives a subpoena for the employer's information. You can have a provision that allows the employer to become involved in the case to protect the confidentiality of that information.
Sure.
When we were preparing this, Jim, you added treat and compensate your employees well and make sure they know it.
Sure.
And yeah. I've always appreciated when you've done this, Jim.
Well, the reason I put that in there is because in my experience, right, employees are most likely to look to leave if they're unhappy, if they feel like they're not being treated fairly or feel like they're not being compensated fairly. And the parenthetical reference in there is actually a case I'm working on right now, where a manager of a company resigned his employment, took a job with a direct competitor, and it turns out that he did so thinking he was going to be more highly compensated, but he was totally ignoring some of the company's benefits as part of that process. Their match on his 401k and also some of the other benefits that he was receiving, bonuses. And so he actually admitted after he had resigned that he had made a mistake. And I think it was in part one that could have been alleviated if the company had been more, I guess, public about the benefits that it was offering its employees and reminding them of that, so that they really knew that the grass wasn't greener at the competitor.
Another tip that I've frequently used when an employee leaves is having the employer look into what the employee was doing in the month or 2 months or so before the employee left.
So how do they do that? How do they conduct that investigation?
So it's a combination of things, and it actually goes with our next point of having a computer use policy. These are common for employers to have, and it simply states that anything an employee does on an employer's work computer, the employer can look at. And so when employers have that policy, I advise my clients to open up the employee's email box. Don't automatically delete their email account from the server. Look at it. See if there's any emails with company information being sent to unknown Gmail accounts, or the account of someone who's at a competitor, or maybe they're emailing a customer and you can see that they're saying, hey, I'm about to leave my job, I'll contact you in 3 months. And so they're trying to park that job for their future employment. That it's a great way to get some initial information about what the employee was doing right before they left, so you know whether their departure was as they would like it to be perceived.
So, and do you occasionally not just rely on the client to do that investigation, but also bring in experts to assist?
Sure. And so that depends on the size of the client and the size of their IT department. At times when there is a lot of information or a lot of evidence of an employee taking information to their new employer, we'll have a forensic examiner come in and
they'll image a computer.
Correct. There you go. They'll image a computer, retrieve that information. That was the R word I was looking for, and so that we have it in a way where we can prove the evidence and the admissibility of that evidence. Another tip I've found that works really well is employer paid cell phone plans.
Sure.
They're common. The cell phone companies retain text messages for 30 days. And so if the employee had an employer cell phone number and the employer's paying for the cell phone plan, contacting the cell phone company and asking them for a copy of all of the text messages for the last 30 days to see who the employee is talking to and what they are saying.
Is it possible, even if the employee has deleted texts, to recover the content of those texts?
Yes, I've had it happen where the employee routinely deleted the text on their phone, but regularly backed up their cell phone to the cloud. And so by backing it up to, in that case, it was an iPhone, by backing it up to Apple's cloud, we were still able to obtain the text messages that the former employee thought they had deleted. So another technique I've used is sending a post-employment letter to the former employee and their new employer. I do this when we have a suspicion that they may not be fully complying with their obligations, but we don't have that smoking gun showing that they're actively using our confidential information or our client's confidential information. And by doing this, it's a simple reminder to the former employee of their obligations, and it puts the new employer on notice that this employee still owes obligations to our client.
Sure. I've even seen situations where that kind of letter, even if it is not particularly threatening, has resulted in the new employer revoking offers to the employee. And it might be because they weren't aware that there were some post employment restrictions. It might be because it caused them to doubt the integrity of that employee. And so it's often helpful to send that kind of letter just to see, because sometimes employees who are seeking a job with a competitor aren't forthcoming that they have post-employment restrictions.
Have you used severance agreements as a way to protect a company's business interests?
I have, and I found that courts are more likely to enforce post-employment restrictions if they are entered into at the termination of employment. And so there might be a situation where you have an employee sign an agreement. You might even be willing to pay something for that in order to increase or enhance your chances of enforcing a non-competition agreement, for example. Judges are far less reluctant to put someone out of a job if they are being paid during the time that they're not working.
And speaking of payment during the time they're not working, do you limit your search for post-employment obligations to the employer strictly to the employee agreements and other documents signed at the start of the employment, or can deferred compensation and other arrangements also include these same types of restrictions?
Sure, it's common for them not just to be in the onboarding documents, but there might be a grant of a stock option, there might be a retention bonus that's paid, or a stay bonus. There are a host of other agreements that employees sign during the course of their employment that can have those kinds of restrictions, and maybe because of the enhanced compensation, or maybe because of an increase in job responsibilities where it didn't make sense to have post-employment restrictions before, it does.
And so the final point here is being consistent in enforcement. What did you mean? Because this was one of the items that you added, Jim.
Sure. So I think, first of all, it's important that your workforce knows that you take these agreements seriously. You expect them to take the agreement seriously as well. And so enforcing agreements when there are breaches delivers that message. And it delivers that message not only to the employees, but also to your competitors or others in the industry. And in that context, right, your competitors are going to be less likely to try to recruit from you if they know that your people have post-employment restrictions and that you will take action to enforce those restrictions.
And with taking actions to enforce the restrictions, would you say turnabout is fair play? If you're going to enforce your restrictions, then you should honor the competitor's restrictions.
I think that's right. I mean, I think if you are going to be standing up or asking us to stand up in front of a judge to enforce your agreements, if you have not acted accordingly with respect to your competitors' agreements, it just makes for an easier argument for the other side to make that either you've got unclean hands because you do the same thing you're complaining about, or that there really aren't any legitimate competitive business interests to protect in this context.
So those are our 10 tips on how to protect your legitimate competitive business interests. Jim will be staying on after this webinar ends and to answer any questions that you may have live.
Yeah, thanks for attending and thanks for participating, Neil.
Thank you.
So I'm going to stay here for a few minutes and see if any of you has any questions. So we just received another question, and that was, how does the politics of our current administration leaning against non-competes affect us going forward in Michigan? That's a great question. And what we're seeing really is more impact in other states right now. Other states, there is a stronger move to limit the situations in which non-competition agreements can be used. Often what states do is they'll look at a salary limit, and for any employee making less than a certain salary, non-competition agreements cannot be enforced against those individuals. Other states are looking at categories of employees to do that. And so, but in Michigan, right now, I have not seen anything. This would most likely happen legislatively. In fact, I think the only enforceable way to do it would be legislatively. I have not seen anything that's gaining strong momentum in the Michigan legislature to kind of mirror what's going on in other states. And I think the question refers to an executive order that President Biden issued, where he asked the his administration to look at ways to make sure that non-competition agreements were not being misused to limit employee mobility. And I know the Department of Justice is taking action against some employers, particularly in the context of no poach or anti-switching agreements, where employers are agreeing amongst themselves not to recruit or hire each other's employees. Those run afoul of antitrust laws, and the Department of Justice is definitely taking aggressive action against those types of arrangements. All right, so that's all the questions that I've seen. Again, I appreciate your attendance, and we look forward to having another Lessons from Litigators presentation in the future. Thank you.